Hi, I'm attorney Renee Osipov with Chelle Law, and we assist nurse practitioners with employment contract issues. Today I'm talking about non-compete clauses and specifically how many locations should a restricted area attach to within a non-compete clause for a nurse practitioner. So before I kind of get into that, we need to back up and kind of talk about what is a non-compete clause. Depending on your state, there are some that non-compete clauses are actually unenforceable, or you have to make a certain amount of money annually in order for the non-compete clause to become enforceable. So you should always check that first, or speak with an attorney about that. And then you want to look at your employment agreement. If you have a non-compete clause, it's normally under the restrictive covenants. Restrictive covenants are just a promise to not to do something. So you're promising a non-compete clause is you're promising not to compete with your former employer. Also in there may be a non-solicitation clause for patients or for employees. So you want to read through that really carefully. A lot of times clients sometimes graze over these areas, but non-compete clauses actually can have serious consequences if you sign your agreement and then later leave and aren't able to work in the area. Sometimes it's large areas and you actually have to move, or it's really difficult to find employment. So non-compete clauses are really, really important. I would say that's one of our biggest areas that we're advising clients on within an employment contract. So with all of that being said, normally it's two parts. So one, you're restricted for a certain period of time. That's anywhere from 1 to 3 years. After your employment has ended with your employer, you are restricted for a period of time to not compete with them. And then for that period of time, then you're going to have a restricted area. So it's normally in miles, but it kind of depends on where you are in the United States. If you're in like New York City, miles is really unreasonable. So you're probably going to go like city blocks. If you're in a rural area, it may be more miles. If you're in a city, it might be less. So it's kind of unique to where you are. So you definitely want to think about, if this job ends, will I be able to find work or will it be really difficult? So we have the time period, we have the restricted area, but here's the tricky part. Sometimes employment contracts talk about, or non-compete clauses talk about locations that restricted area attaches to. So let's just use an example of 10 miles. You're restricted from 10 miles from certain locations. Now, it should be, in my opinion, only from your primary location, where you're primarily giving your services. That's where in my opinion, you should be restricted from. But you want to be careful. Sometimes there's language in your employment contract that states that restricted area attaches to any location that you provide services for them while you're employed. So if you cover for someone while they're on vacation, the non-compete would attach to it. Even for a day, if someone's sick and you go to a different location, your non-compete clause now attaches there. So if you have multiple locations, this can knock out a huge area of a state even. So you want to be really careful on that. The other one that's really tricky is whenever you see language in a employment contract that states you're restricted from any location of the practice. That's really difficult. We don't have a crystal ball. We don't know in the future if they expand, if they're going to have more locations. So let's say they have 3 whenever you start, but they've bought out a couple of practices. Now they have 6, and you're restricted from, remember that 10 miles is from every one of those locations. So then we get into a huge area that's restricted. So in my opinion, in non-compete clauses, you should be restricted only from your primary location that you're giving services at. That's what the restricted area should attach to. And again, for a reasonable period of time. In my opinion, it would be 1 year, but I have seen anywhere from 1 to 3 years that you're restricted. So In summary, you want to be able to read your non-compete clause and know exactly how long and what location am I restricted from. And you want to try to negotiate it to your primary location. It's important, I think, to consult an attorney with these type of issues, just because non-compete clauses are a little complicated, and you want to make sure that you're getting it reviewed by someone who knows the laws in your state, and then also who understands how this is going to affect you and is able to explain that to you so you fully understand what you're signing. If you would like more information on non-compete clauses or really just anything within the employment contract issues, you can check out our website. Our contact information is on there as well. Chelle Law, CHELLE law.com. Thanks.